Okay, welcome everybody to the United States Court of Appeals for the 12th Circuit is now in session with the Honorable Judges Meyer, Henry, and Hawks presiding. I now will hand it over to the Chief Judge and she can get things started.
Thank you. Mr. Shramkowski, are you going to start this argument?
Yes, Your Honor.
All right, let's hear what you have to say.
Thank you, Chief Judge, and may it please the court. My name is Alex Shramkowski, and I, along with my co-counsel, Ms. Madeline Gilmore, represent appellants William Bremerly and Bremerly Family Farms. At this time, we would request 2 minutes for rebuttal. Federal rules govern federal courts, but Wistabama's Public Speech Act undermines that principle by dismissing otherwise trial-worthy claims. This court should join the majority of its sister circuits and refuse to fundamentally alter cases proceeding in federal court. Ms. Gilmore will explain why the Bremerly's defamation lawsuit falls outside the scope of the Public Speech Act. But first, I will explain why, as a threshold matter, the statute cannot apply in a federal diversity action. This court should reverse the decision of the district court below for 2 reasons. First, the Public Speech Act directly collides with federal rules of civil procedure. And secondly, and alternatively, the Public Speech Act undermines the Bremerly's 7th Amendment right to a trial by jury. As the district court found below on page 7 of its memorandum opinion and order, the Wistabama statute at issue is obviously procedural. And when a court sitting in diversity has to examine whether or not to apply a state procedural statute while sitting in diversity, it uses the Supreme Court's guiding framework from Hannah versus Plummer.
Before we get to that, Mr. Shramkowski, you say the statute is totally procedural. But what about the fact that it has a mandate for attorney's fees for the movement if the movement prevails? Are you saying that a statute that mandates an award of money to someone is a procedural statute?
Not always, Your Honor. The guiding framework from Hannah only asks whether a statute is rationally capable of being described as procedural. It doesn't have to be 100% procedural to go down the Hannah tracks of analysis in an eerie question. Here, the lower court gave credence to the idea that it could be rationally capable of being described as a procedural statute. And so the attorney's fees provision matters. It just comes up later in the Hannah analysis. Do
you agree that the fact that the statute mandates attorney's fees if the movement prevails, that is a substantive requirement, not a procedural one?
It could be. In other cases, attorney's fees statutes that are simply attorney's fees statutes and nothing more have been considered substantive for an eerie analysis. The problem comes into play when, unlike Rule 11, which assigns attorney's fees when a lawsuit is deemed frivolous, and that is a discretionary matter assigned to the judge in that particular case, a statute here which has an entirely different procedure that is separate from Rules 26's discovery features or Rule 56's summary judgment features, is then being commanded to give out attorney's fees. That creates a direct collision between Rules 11, 26, and 56 with the Wistabama anti-SLAPP statute. Ultimately, it's up for this court to decide whether or not it believes that the rules directly collide with the statute in this case, which would open up one Hannah track of analysis, or rather, if they just indirectly collide. Because if they indirectly collide, then the only analysis that has to take place is the twin aims of Erie compared to a federal countervailing interest, such as the 7th Amendment right to a jury trial.
To take it back to the just basic procedural versus substantive distinction with respect to attorney's fees, what is your best case for contending that attorney's fees are non-substantive?
Your Honor, to clarify, attorney's fees, when they exist on their own, have been deemed substantive by the Supreme Court. The difference is when attorney's fees are baked into a procedural statute. And that's what the DC Circuit examined in the Abbas versus Foreign Policy case. Then Judge Kavanaugh spoke at length about how if the DC Circuit or the DC Council merely wanted to create a attorney's fee statute, then it could have done that without prescribing the procedures that should take place in federal court. When the state legislature steps into that role and tries to alter the fundamental character of a federal court, it steps too far and creates a direct collision with the federal rules.
Sorry, go ahead, finish your response.
Well, if the court agrees that it is a direct collision, then that would trigger the supremacy clause, and the supremacy clause would control in this case as long as the federal rules at issue were validly promulgated under the Rules Enabling Act, which merely asks whether or not it really regulates procedure, as the court has said in Civic and then later affirmed in Shady Grove, or if the rules at issue abridge, enlarge, or modify a state-created right under subsection B of that statute. Here, the rules are really regulating procedure. None of the rules that are at issue in this case, when viewed in a vacuum outside of the statute, regulate the substance of a particular party's rights or obligations. Rule 11 merely discusses whether or not a party can bring a frivolous lawsuit and gives the judge discretion to award attorney's fees. Rule 26 only discusses the internal operation of discovery procedures in court. And Rule 56 only discusses whether or not a judge can dismiss a lawsuit when there is no genuine dispute of material fact. Since all of those rules really regulate procedure, if the state statute is trying to answer those same questions differently, then the supremacy clause demands that lower courts apply the rules over the state statute.
But counsel, where is the direct collision with any of those rules? How does it supplant or conflict with what those rules require?
Judge, Justice Ginsburg spoke at length in her Shady Grove dissent about what a direct collision means, and that is essentially when a rule answers a question one way and the statute answers a question a different way. So take, for example, in the Rule 56 and 26 environment, Rule 56 incorporates Rule 26's broad-ranging discovery features. As long as a party has filed a motion for summary judgment, as the court explained in Anderson versus Liberty Lobby, they're entitled to full discovery to discover whatever materials that they might need to create a genuine issue of material fact for trial. Whereas the Wisconsin anti-SLAPP statute in sections 4 and 5 puts a mandatory stay on discovery features. And that stay
you could have asked for discovery. You could have asked for discovery in this case, and I'm really surprised that you didn't, given that, I guess we'll hear from your co-counsel, but given that you dispute that there's a huge dispute about whether or not the statements at issue were in fact defamatory or not, why didn't you ask for discovery? And the fact that you could have asked for discovery seems to cut against the argument you're making to my colleague here.
Well, 2 points on that, Your Honor. First, as a threshold matter, the pointing out of the fact that the statute differs from how normal discovery procedures works in the run of cases is normally what the Erie analysis is aimed at, rather than the facts of the particular case. But to the grains of your question, there was already enough facts in the record when the Bremerleys submitted declarations, as opposed to Ms. Finkelworth and Ms. Cardillo's affidavits. Those were enough without discovery to create a genuine issue of material fact in the record. Because as Mr. Bremerley writes in the last paragraph of his affidavit, he believed that he was bringing this lawsuit with merit, that he was bringing it because he thought that they had been defamed in the public sphere. He wasn't bringing the lawsuit merely to harass the opposing party. And it's inappropriate, even if this court doesn't believe that there's a direct collision under Hannah Track 1, it's inappropriate for the judge to assume the fact finder's role of determining whether William Bremerley is lying when he says that. But
Mr. Bremer, but he says, as I read his declaration, that Ms. Cardillo is lying. That's what he says. He says she's lying about what she claimed she saw when she was an undercover person at his farm. And yet he doesn't want to take her deposition to prove that she's lying. I'm very perplexed by that. In other words, you seem to say that your position was you were just going to put her on the stand and cross-examine her for the first time and see what she had to say. And that's how you were going to resolve the disputed issues of fact. Am I understanding your position correctly?
Your Honor, the Bremerleys certainly could have done that, although there is certainly also a capability where, had the summary judgment motion not been filed, under the Wistabamba Anti-SLAPP Act, and discovery had been allowed to continue, that depositions could have been taken in this case. But the very problem that Your Honor is alluding to is that the judge is having to make a determination in this case about whether William Bremerly is telling the truth, whether Blaine Cardillo is telling the truth, or whether neither are telling the truth. And that is a sacred function of the jury that has been left to the jury in cases as far back as Byrd versus Blue Ridge Electrical Cooperative. The Supreme Court said that the one key area of the Constitution that has regularly outweighed the competing eerie interests of forum shopping and the inequitable administration of justice is preserving a litigant's Seventh Amendment right to a jury trial. In defamation suits, there are plenty of triable issues that have to be confronted with a jury. In Rosenblum versus Metro Media, for example, the Supreme Court discussed about how credibility issues, the falsity or truth of particular statements, and the credibility determinations about why a party is bringing suit are all questions that are typically reserved for a jury. And the second restatement on torts confirms that very view.
So I assume your position then is that we should remand this case back to the trial court, forget about the anti-SLAPP statute, and just proceed with a regular old civil discovery kind of case and have discovery and see what happens in the discovery process and then move to a trial. That's what even though you waived your right to seek any discovery, that's what you want us to do now, correct?
Your Honor, this court should remand for that kind of a determination. To the extent that this court is worried about the attorney's fees provision that's found in the statute, as some of the questions have alluded to, I mean, attorney's fees are still regularly allocatable under Rule 11 if a judge comes to an exact determination, just like they did in this case, that they believe that a lawsuit violated, Rule 56 or was brought frivolously or without merit. So the attorney's fees remedy—
it's discretionary. It's discretionary versus what the anti-SLAPP suit provides, which is a mandatory award of attorney's fees. You see a distinction there?
Exactly, Your Honor. And that distinction is what causes a direct collision in the language of cases like Shady Grove and Burlington Northern. So to the extent that that is a direct collision, the Supremacy Clause should preempt the Public Speech Act as it applies to a federal diversity action. Ultimately, both of the tracks are ones that this court could take to resolve the question. If the court is worried about whether or not in practice a particular party's rights are being infringed, if William Bremerly can call Blaine Cardillo a liar and Blaine Cardillo can call William Bremerly a liar, that is ultimately a question that the jury should be engaging in. Nearly a century ago in Jacob versus New York City, the Supreme Court talked about how district courts should jealously guard the fundamental character of federal courts in assigning certain roles to judges and certain roles to juries. And this is a classic example of a role that is left normally to the jury, because judges shouldn't be in the thorny issue of determining which party is lying in a particular case. That's entirely why the founders—
Does that just suggest that if the court looks at the affidavits and determines that there is a disputed issue of fact, that the anti-SLAPP motion should fail and then we should move on? How is your jury right affected if there is not a disputed, there are no disputed facts with respect to the anti-SLAPP motion, and that needs to be decided first?
2 points on that, Your Honor. First, if the court were really engaging in a Rule 56 style analysis and they found that there was no genuine dispute of material fact, that would not violate the Constitution. Courts have regularly considered that Rule 56 is constitutional as long as they're applying the Anderson versus Liberty Lobby lens of what a reasonable jury would decide in a particular case if there's no controversy. But Section 3 of the statute shows that they're actually judging it on an entirely different standard, that it was filed without merit and primarily brought to chill the expression of free speech.
Doesn't the statute explicitly state that the summary judgment standard is being applied here? And how is this different from a summary judgment motion then that would be filed under Rule 56, which likewise doesn't require that discovery be completed before you file it?
Chief Judge, I see my time has expired. Can I briefly answer that question?
Yes.
Judge, as the last page of the district court's memorandum and order shows, the judge made a determination in this case that it was filed without merit, which is not what is normally being done under Rule 56. Under Rule 56, the sole job for a judge is to determine whether there is a dispute of material fact necessary to go on to a jury. Since those modes of analysis differ, it should not apply in favor of the Seventh Amendment right of the Bremer-Lees. Thank you.
Thank you. We're waiting for Ms. Gilmore. There she is. Hello, Ms. Gilmore. How are you?
I'm doing well. How are you?
Good. Good to see you. Let's hear what you have to say about this matter.
Thank you, Chief Judge. And may it please the court, my name is Madeline Gilmore, and I also represent the appellants. This case is about the logical limits of the Wisconsin Public Speech Act. While the statute is broad, it cannot have an unlimited scope. Mr. Shrimkowski explained why the act cannot apply in this federal diversity lawsuit. I will now explain why, even if the act can properly be applied to this suit, it does not encompass Animal Action Now's defamatory activity. This court should reverse the district court for two reasons. First, because the Animal Action Now's original statement was defamatory, it is not speech protected by applicable law as required by the language of the act. Second,
can I ask you a question? Sorry, I know you wanted to outline your argument, but I just want to ask you while we're on this one. Can you tell me precisely what are the defamatory statements at issue in this case?
Yes, Your Honor. The specific statements that motivated the Bremer-Lees lawsuit were the release of the video, the appeal to Wegmans grocery stores in the video, and the purported news report or investigative report with the findings of Animal Action Now that describe what they allege are depicted in the video. Those are the statements that caused the primary injury of Wegmans grocery stores canceling their contract with the Bremer-Lees. And so those are the statements that are at issue.
Okay, so I just want to understand, because you said it's the release of the video, the appeal to for Wegmans to dump them, and then the news report. Those were all vehicles for the defamatory statement. But what is the actual defamatory statement? Because as I understand what happened here, this was just Ms. Cardillo saying, here's what I saw when I was undercover, and here's a video that I took of what I saw. Is that, do I understand that those are the statements that you're claiming are defamatory?
Yes, Your Honor, in part. What Blaine Cardillo says she saw, she concludes that it was a violation of the Wisconsin animal cruelty law, which the Bremer-Lees maintain is false, and that no animal abuse by the definition under the law took place. For example, she alleges that the Bremer-Lees use battery cages, while William Bremerly in his affidavit makes clear that they use a tiered aviary cage system that has been approved by reporters and animal abuse auditors.
Okay, now I understand. And as I also understand, there's a lot of dispute about. So there's a huge factual dispute here about whether or not these are actually defamatory statements or true statements. And so I assume you agree with your colleague that this whole thing should be remanded to the trial court to resolve the disputed factual issues.
Yes, Your Honor. The trial court here made impermissible credibility determinations in the face of two competing affidavits. And the Bremer-Lees didn't seek more discovery because the Bremer-Lees had enough discovery to show with the competing affidavits that there was a genuine dispute of material fact. So while more discovery might be needed before trial to prepare for trial, it was not needed in order to overcome their burden in this case. And the statute actually places the burden on Animal Action Now as the party invoking the Act's protections. Animal Action Now is required to show that 4 statutory elements are present, which is that
before we get to that, because I just want to make sure I understand. So you're saying the declaration that your client put in this case raises enough of a factual dispute about these statements being defamatory or not being defamatory. And I read that affidavit, and there's not much. I like the answer you just gave me, which is the defamatory statement is saying that the way he treats his animals violates the anti-cruelty statute. That I get why you would say that's defamatory, but I don't see him saying that in his declaration. I think all he said is they're false. The statements he made are false. There's no description of precisely what about the statements he made were false, unless I read that affidavit wrong. That's one thing I want to say. I want to see what you have to say about that. And the other thing I wanted to add, when you say the trial court made factual determinations, credibility determinations, based on the declaration, didn't the trial court also watch the videos?
Your Honor, there's no evidence in the record that the trial court did watch the videos. And in order to review the trial court's merits analysis, we would need it not to be omitted from the record in order to point to specific ways in which they erroneously found facts. However, the trial court, it never mentioned, there's no evidence that it ever even looked at the video to verify the veracity. Instead, according to the district court, it simply heard oral argument from the parties. And furthermore, to the extent that William Brummerly's affidavit is not detailed, he's not the party with the burden in this case. He
Counsel,
set forth.
I believe that the district court's decision actually did say the court has watched the 2 short video clips that Animal Action Now produced. So in view of that fact, if that is true, how does that change your analysis?
Your Honor, even if the video itself was shown, the video itself contains essentially a few clips of footage from inside the Brummerly's farm, but it doesn't depict what Blaine Cardillo and Animal Action Now say that it depicts. And so to the extent that the video was considered by the trial court, it might not have necessarily been helpful in deciding the merits of the case, especially considering the competing factual disputes.
Yeah, and does it matter for your argument? Because watching a video, that's not the same thing as seeing somebody on the stand subject to cross-examination, is it?
No, Your Honor. And the certified question in this case is more about whether the statements by Animal Action Now qualify as protected activity. And so it's more focused on a question of law, which is primarily why the merits analysis was omitted. But even if the district court didn't make erroneous factual findings, which it is our position that it did, the statements by Animal Action Now were not made in the manners required by subsections 2A, 2B, or 2C of the Act. And each one of the 4 statutory elements must be present in order to qualify for the Act's protections and to bar the Brummerly's lawsuit.
Well, let's talk about that a little bit, because picking up on some of your early responses to Judge Meyer's questions, you noted the vehicles that Animal Action Now used to disseminate this information, and they included a video that it published publicly to get as much attention to it as possible, interviews with news media. How is that type of advocacy not exactly the type of advocacy that paragraph 2 of the statute actually contemplates?
Your Honor, it's not contemplated in paragraph 2 because the statements that actually motivated the Brummerly's lawsuit that but for causation element was not the 2 individual statements that Blaine Cardillo and Alexandra Finkelworth made to the reporters. Those came subsequent to the statements on their social media and website. And so those statements on the social media and website were not made in or in connection with a movie or a news report or other similar work as required by Section C.
Okay. So, counsel, the statute contains a sort of catch-all at the end for other similar work. And there is a canon of construction called Nascitur Associs that dictates that the meaning of a kind of unclear term like that should be determined by considering the words with which it's associated in context. So how does that catch-all phrase not get defined by the general characteristics of the words that precede it? Meaning they're all publicly available works that convey ideas and arguments. Don't we fall into that broader category?
Your Honor, Nascitur Associs and Ad Justum Generis are helpful in interpreting this section of the statute. the unifying thread of all of the items listed is that they are some form of commercial media. And so the statements must have been connected to a form of commercial media. Other support for this comes from a case called Bongino versus Daily Beast Company, where a Florida court had an opportunity to interpret a statute with almost identical language as Section C. And that court held that it was essentially a media provision designed to protect those engaged in the production of news and commercial media. And so the fact that Animal Action Now posted it on their website, calling it a news release, doesn't make it an official form of commercial media.
And so to be clear, would it have been protected under this statute then if a competitor had gotten a hold of this video footage and posted it on its own website, just because that would make it commercial?
No, Your Honor. What's important is what is in the mind of the speaker at the time that the statements are made. And the use of the past tense of the word made implies a temporal requirement, that the statements have to have a connection at the time they are uttered. And so if it was recruited by a news entity and it was in contemplation of being for a news report the entire time, that might qualify it for the Act's protections. But here, hoping or having a unilateral desire that it will become the subject of a subsequent news report cannot create a retroactive existence without giving the Act an unlimited scope.
So these statements fall outside the scope of the Act because they were made after the organization talked to news media. And even if they were made before the organization subsequently talks to news media, we have to look at that in this very, very narrow scope of time as to exactly when the alleged defamatory statements were made, and say that they were not made in connection with efforts to educate the news media because they came after one news interview and maybe before the next. That's what you're saying?
Not exactly, Your Honor. The statements here were that the statements on the website were made first. The news and the release in the video were made first. And only then did two reporters from UBS and Associated Print interview Alexandra Finkelworth and Blaine Cardillo. So the fact that the original statements were not made in connection or in contemplation of a news report, because the news report didn't exist yet, nobody had talked about doing it yet. And so they can't retroactively establish the existence. Otherwise, any individual making any statement could be verified or claimed to be within the scope of Section C and give
These
it
aren't any individuals making any statement. I mean, if you look at the affidavits that the district court gave credit to, Animal Action Now says that we published this for a purpose, and that purpose is consistent with, and I think it may be a fair inference, that it was in contemplation of this further publication of the information that subsequently happened. It seems to me that you're parsing out sort of the words. Do you contend that Animal Action Now did not intend to get news coverage of this, that's not in the record?
No, Your Honor. Animal Action Now clearly did intend for this to be released for broader public consumption. However, they simply did not have any reasonable basis at the time that they released the statements and published them that there would be a subsequent news report. And in order for any individual to be able to read the statute and be on notice and conform their conduct to the statute, to know whether or not their statements are protected, they have to know when the statements are connected to one of these items listed at the time they're made. Furthermore, the fact, even if Section C is read much more broadly than the Brehm release contend it should be, the fact remains that Animal Action Now has not satisfied all four of the statutory elements, because there is also no proof in the record that the Brehm release brought this action because of and primarily to chill a valid exercise of free speech, because their speech is not protected as required by the definition of free speech and protection in connection with public issues, because defamation is outside the scope of protection under the First Amendment. For these reasons and more, we ask that this court reverse the district court. Thank you.
Thank you. Hello. And is it pronounced Ms. Zielinski? How do you pronounce your last name?
Zelensky. That was close.
Zielinski. Zielinski.
Yes.
Thank you very much.
Thank you.
All right, you're on.
Thanks. Good afternoon, Your Honors, and may it please the court. My name is Morgan Zelensky, and I represent respondents, Animal Action Now, and Blaine Cardio. The 10th Amendment provides states with the right to create substantive protections against meritless lawsuits that are primarily brought to chill protected speech, like the suit in this case. This court should affirm the district court's decision, first, because applying Wiscabama's statute furthers Erie's twin aims of discouraging forum shopping and avoiding an inequitable administration of the law. Second, the federal rules are not sufficiently broad to control the issue of when to dispose of a meritless claim that's primarily brought to chill protected speech, and the state statute is not in conflict with the federal rules. And finally, although Wiscabama's statute does contain procedural elements, it also gives substantive rights, and the substantive rights are so bound with the procedure that the two cannot be separated. Thus, the state statute must apply in this case.
Oh, I want to start with the last question, the last point you made. You're saying that we can't separate out the right. Why can't this court find that the procedure for filing the expedited or early motion for summary judgment, that's procedural, but the right to attorney's fees that the statute mandates, that's a substantive right. And why can't we separate those out and say, we're going to apply in this diversity action, we're going to apply the federal procedure because that's what's required, but we're also going to apply the state substantive right, which is that if you win your motion, you are entitled to attorney's fees. You're saying we can't do that. It has to be all or nothing.
Correct. The court should not break apart the state statute because the procedural elements, like the stay of discovery, and then the substantive element, the right to attorney's fees and costs, individually mean much less than if they are read together. The stay of discovery almost defines the scope of the right to attorney's fees and costs. And that's really the whole purpose of the state statute, is to prevent a defendant from unnecessarily going through a lengthy discovery and litigation process when there's a claim that's meritless and just brought primarily to chill speech.
The court is allowed to grant discovery under this statute. I mean, what's the big deal here? Isn't it just a matter of timing? I mean, you can always file a motion for summary judgment under the federal rules. You can file it as early as you want to. You can even ask the court to expedite a motion for summary judgment. So it doesn't really, you're not really getting anything extra from this statute, as I see it, except for your right to attorney's fees. And I find it interesting that you're saying, no, don't give us that right to attorney's fees. You either find that the statute applies in totality or it doesn't apply at all. But that seems to be what you're saying.
The defendants in this case, maybe they could succeed on the federal rule 56 motion. So maybe the defendants in this case may be happy if they have a summary judgment motion and added on attorney's fees, but that frustrates the state's purpose, and the state created this statute.
You are the defendant. Aren't
Yes.
you the defendant? Aren't you representing the defendant?
Yes.
So don't you want to embrace? It seems like you would want to embrace that as a potential outcome of this case.
Yes, that's a potential outcome, but the bigger picture is future defendants and the risk of chilling of free speech for all citizens.
But can't that be protected through other mechanisms under the federal rules? I take that to be Judge Meyer's sort of point, like your 1A concerns, your First Amendment concerns, you could raise them as defense in other motions practice, Rule 12, Rule 56. And so it does seem to be just sort of all about timing your invocation of the anti-SLAPP statute here, rather than say bringing them as a separate motion. And so to me, it seems like you could still set that precedent that protects those future defendants from these sort of frivolous bullying suits if you used the normal mechanisms of the federal rules. So I'm wondering what it is about the anti-SLAPP statute in particular that, there's really important for you to use as a vehicle here.
The most important substantive nature of the statute is the attorney's fees and costs, and that isn't guaranteed under the federal rules in any federal rule. So that really is a right that the state is granting. And then in context with the stay of discovery, and that the state lays out that these SLAPP lawsuits are clearly a problem and necessary protections for the defendant. The legislature deemed that necessary, that this statute is necessary to protect against strategic litigation against public participation.
Okay, so would you deem those items that you just enumerated to be substantive, or is it just the attorney's fees and costs provision that you are tagging with the substantive designation here?
Alone, looking at if the court were to break apart the sections of the statute alone, just reading from the plain language, then the attorney's fees and costs are substantive in nature, and then read alone, discovery would be, the stay of discovery would be procedural. But the point is that they're together for a reason, and together they become intertwined and substantive because it is outcome determinative. The defendants will have a different outcome in federal court than they would in state court. And that different outcome includes, there's still a different outcome if the court applies Federal Rule 56 and adds on the attorney's fees. That's still a different outcome than the defendants would get in state court under the Wisconsin statute. So it would cause forum shopping and inequitable administration of the law, because in Wisconsin, a plaintiff doesn't have the right to slap a individual or entity with one of these with a lawsuit to primarily brought to chill and punish protected speech, whereas then a plaintiff could do exactly that in federal court. So the defendant's only protection really is through the state statute, and that's the purpose is laid out in the statute in section 1 of the statute. It isn't in an abstract legislative history. The legislature clearly thought it was important enough to write into the statute why it was making this statute and why it's important, and that it is creating a substantive right under its police powers. So the whole statute should apply.
Let me switch to another matter, which is, so you disagree that there's a factual dispute about whether or not these statements were defamatory? How can you take that position in light of the conflicting affidavits that were submitted in the trial court? Or are you agreeing with your opposing counsel that the trial court made a credibility determination here?
No, there is no factual dispute. As you mentioned earlier, the Bremerleys made a legal conclusion in Mr. Bremerley's affidavit. He said all statements made by Animal Action Now are false. They have to be. No other reasoning as to what exactly is false and how or why. So Animal Action Now doesn't even have the ability to defend themselves because they don't know what it is that Mr. Bremerley is alleging is false.
Well, wait a minute, maybe saying every single thing that she said is false. She's a liar. He says in his affidavit that she's lying. Every statement she made to anybody is false. What else do you need to know?
Anything to support that, and he doesn't go into why. And whereas
he's got a sworn declaration. He runs the farm. He seems to know. I mean, his family's run this farm for over 100 years. He's the one. He's there on the scene with the hens and the eggs. He seems to know what he's talking about, or he purports to know what he's talking about. And he's saying under penalty of perjury, her statements are false. I mean, doesn't that set up a dispute on the factual issue in the case that the trial court has to decide through some kind of adversarial process?
No, because Mr. Bremerly is, again, just alleging everything is false because it has to be. And whereas.
So it sounds to me like what you were saying is that Mr. Bremerly's declaration is self-serving and uncorroborated. Can I exclude it on that basis such that it doesn't become evidence that creates a dispute of fact? And what is your authority for that?
So, if I understand your question correctly, exclude Mr. Bremerly's affidavit.
As self-serving and uncorroborated. What's your authority for that argument?
I don't think the court doesn't need to exclude his affidavit as self-serving. I just think his affidavit shows that there isn't a genuine dispute.
But even if his affidavit is conclusory, it doesn't say that much. This is a summary judgment proceeding under this statute, right? You seem to be proceeding as though this was his case to prove, the Bremerly's case to prove. That's the, you know, that's the merits decision after this, even though this statute sort of subsumes a determination that the merits were frivolous. So wouldn't it be helpful if we got some further discovery? Why is it his obligation to say any more than all of this is false in order to avoid application of this statute without further discovery, when it's equally the party's burden to prove that they're entitled to judgment under this statute?
Mr. Bremerly's affidavit, I think, shows that there is nothing left to discover. This was the Bremerly's second opportunity. This is a supplemental affidavit. So he had the complaint and then again for the supplemental affidavit, and Mr. Bremerly, like discussed earlier, hasn't asked for discovery either. So the plaintiffs must not think discovery is necessary either. But
let me go at it this way and just ask this question, which is a little more succinct. Do you agree that it's your obligation as a summary judgment movement under this statute to prove that his suit was without merit under paragraph 3?
yes.
Okay.
And they added primarily brought to chill protected speech.
What's the story with this supplemental affidavit? I didn't see that. Are you saying there was a verified complaint in this case? I don't know what you're talking about, the supplemental affidavit.
In section 4 of the statute, the claimant, the plaintiff, can respond and submit supplemental affidavits. So that's Mr. Bremerly's affidavit. So he already had the opportunity to submit something else when he knew that the defendants were invoking this statute already.
Opportunity, but not obligation, right? This goes back to, I guess, what I think is my point. How far do we have, is it your obligation to show that the statements are truthful, are not false?
It is, but it goes back to Mr. Bremerly's affidavit saying everything is false because it has to be. So that's just a legal conclusion, and Animal Action Now has put out, again, Blaine Cardillo just recorded what she saw, and it's her opinion about the cruel treatment, and that's what was
Are there actual factual disputes though in terms of, for example, the caging system that's used? Doesn't Mr. Bremerly's declaration create a dispute as to like what type of, whether it was battery cages or some other type of caging system, and how does that play into this analysis?
It doesn't play into the analysis because a caged tier system is equivalent to a battery cage system, and Animal Action Now is not saying that one is more cruel than the other, so it's not necessary to include in the analysis.
Can I just ask you, I'm still a little confused about what you keep saying. He says it's false because it has to be. What has to be because why? Because he's been audited by this humane outfit that said he's in compliance with their standards. What are you saying when you say his affidavit says it's false because it has to be false? I'm not following that part.
In paragraph 12 of Mr. Bermley's affidavit, that's where that language is. It has to be. And then he goes on to state, like you were just saying, he's audited, has these different certifications, but both can be true. Just because you're passing your inspections does not mean you are also not treating animals cruelly. So,
All right, thank you very much. Your time is up.
thank you.
Thank you. And I think we're going to hear from Mr. Shrenkowski, who's doing the rebuttal. Oh,
Nope, there's another.
I'm sorry. I
have one
forgot
more.
we have another respondent or appellee. Yes. Mr. Hardy,
Yes, Your Honor.
you're on.
Good afternoon, Your Honors, and may it please the court. My name is Kai Hardy, and I represent respondents in this case, Ms. Blaine Cardillo and Animal Action Now. By enacting the Public Speech and Participation Act, the Wisconsin legislature sought to protect the rights of its citizens to speak freely about issues of public concern without having to worry about frivolous lawsuits brought primarily to repress that speech. This court should affirm the district court's holding, first, because under the plain language of the act, respondent speech activities fall under the definition of free speech in connection with public issues. And second, the Bremerleys filed their lawsuit primarily because respondents engaged in free speech in connection with public issues. Turning to my first point, the Wisconsin anti-SLAPP law defines what free speech in connection with public issues includes, and respondent speech falls within section 2, both subsection B and C. Subsection B defines free speech in connection with public issues as speech that is made that relates to an issue that is currently under consideration by a legislative body. And in this case, as the district court's opinion on page 2 notes, that the treatment of animals in agriculture in the food system is being considered and is motivated by undercover investigations such as that of Ms. Cardillo and Animal Action Now.
You agree though that if in fact the statements are defamatory, they're not protected by this statute, correct?
Correct.
And do you disagree that there's a factual dispute about whether or not the statements are defamatory?
So there is no factual dispute because the Bremerleys have not alleged anything, as co-counsel mentioned. If you look at Bremerley's affidavit, in paragraph 12 is the main paragraph in which they allege something. And in that paragraph, they allege that the statements made by Animal Action Now as to that the Bremerleys treat their hens cruelly is false. And they go on to reason that it has to be. And then they go on to list third-party certifiers. However, they don't state anything there. There's no specific, there's a ton of speech that Animal Action Now and Cardillo engaged in, including a recorded video message, social media posts, news interviews, as well as uploads to the website.
In paragraph 16 of his affidavit, he says, I vigorously protested and explained that everything in the videos was false and was portraying our farm in a completely inaccurate light. Isn't that enough to create a dispute about the crucial fact at issue in this case?
First, the portrayal that it portrays Mr. Bremerley in a negative light, that also isn't a factual dispute, just given the First Amendment's presumption of speech being free, unless, like Your Honor mentioned, it falls within the category of defamation. But the Bremerleys have not alleged a defamation claim. As the lower court held, they found that the Bremerleys' claim was without merit. And that issue is actually not even before the court. So we read that as a concession that the Bremerleys' complaint is without merit And the only way that they can bring their lawsuit is if it wasn't filed primarily because respondents engaged in speech, and the speech engaged in by respondents does not constitute free speech in connection with public issues under the Act. Therefore, the merits of this case of their pleadings have been decided by the lower court and have not been brought in on the briefing order.
I know, but we're the Court of Appeals. We're the next court. We're trying to figure out if the district court made a mistake
Correct,
in
but
deciding this.
yes, but the party that is appealing has an obligation to bring the questions for appeal to this court. The question has not been raised to this court. There's only two questions in the briefing order. First, whether the speech engaged in by respondents constitutes free speech in connection with public issues. And second, that the lawsuit was motivated primarily because respondents engaged in speech.
But if it's not free speech, if it's defamatory, it's not free speech that's protected, correct?
Correct.
So,
But
so it is raised by the first question, isn't it?
the first question looks at the statements or the speech as defined in the statute. Free speech in connection with public issues is a First Amendment question, but in this case, it's defined. And free speech in connection with public issues includes statements made before a legislative body that are issues, and as well as subsection C.
But if they're defamatory statements made to a public body, they're not protected, correct?
Correct.
Okay.
Yes.
So why isn't that whole issue? Why isn't that whole issue about whether this is really defamation and whether there's a factual dispute that has to be resolved through an adversarial proceeding? Why isn't that all subsumed by the first question? You seem to be saying it's off limits to go there. It's not part of the first question, but why isn't it part of the first question?
It's not off limits. It's just that the Brumleys haven't alleged a defamation claim. They haven't alleged every element of a defamation claim.
What elements are they missing?
So the Brumleys have not properly alleged the falsity claim. Defamation requires that a statement must be false and it must be made with at least negligent regard to whether or not it was true. But in the Brumleys affidavit, like I mentioned earlier, they don't properly allege a claim. They don't have sufficient facts to support that claim. It's a conclusion. That statements made were false is a legal conclusion because it is an element of defamation. Falsity is an element. And so in order to support the falsity, a plaintiff has to give more than just say it has to be, and we have third-party certifications, because that doesn't necessarily follow from the fact that you receive third-party certifications that you don't treat your animals cruelly as well. And the 11th Circuit spent some time on this without merit provision, which is really unique to Wisconsin, and Florida is the only other state that uses the exact phrase without merit. And the way the 11th Circuit in Perrick v. CBS Corp analyzed the without merit for a defamation suit similar to this is that they went through each element of defamation and they found that the plaintiff did not properly allege that the publication was false, because and they went into detail. They went through each claim and essentially found that the statements weren't false and declined to adopt the reasoning of plaintiff as to why they were false.
So I take it that your position then is on this issue of merit and what constitutes defamation, that you're telling us that all of the facts that exist are basically your facts and that everything from the other side is just mere conclusion, and so the district court was right. If we decide differently, because we've pressed you on this a bunch, and decide that there is a dispute of fact there, does that deny you access to the anti-SLAPP statute? Does that sort of end the inquiry, and so we remand it for the district court to go on with further proceedings in federal court under the federal rules where these issues might be brought up in the case separately? Or is it still possible for the anti-SLAPP statute to apply, right? Because the anti-SLAPP statute chooses summary judgment as its vehicle, and so presumably operates once we have an undisputed set of facts. if we're right, or we think that you're wrong, at least, that there is a dispute of fact, is there a reason this gets remanded to the district court to address that in the context of the anti-SLAPP statute? Or do you agree and concede that we're done with respect to the Public Speech Act?
So a defendant, Animal Action Now, they can invoke the Public Speech Act if what their speech is free speech in connection with public issues. And defendants have to prove both that plaintiff's claim is without merit and is primarily brought to chill free speech. And the way I read it, it's as simple as that. There's, if defendant fails to allege one of those three elements, then the act is not available as a method to dismiss it. And so really the burden is on the defendants, if that answers your question.
I think it does, although that feels like you're putting too much pressure on your own shoulders, sort of. I mean, what if, I guess what I'm saying is, what if we're inclined to believe that you have done those things you've just mentioned, that you said that this chills speech, that you said that this is frivolous and all that, and I look at this statute and I look at its purposes and I say, well, man, this could really be the Bremerleys bullying them about a bit. But I'm going to deny these defendants access to using this statute, this Public Speech Act, because it's set up with a vehicle of summary judgment. And so we need undisputed facts. And here we're hammering you and saying, man, but it seems like there are a lot of disputed relevant facts. If there are relevant disputed facts, despite the situation being that you have said that this chills public speech, that this is just bullying us about, and that everything else about this Public Speech Act applies, are we done? Or is there something still to be done to allow an anti-SLAPP process to move forward on remand?
Yeah, so the anti-SLAPP process can move forward on remand once the dispute is resolved by the lower courts. If, just for the sake of argument, stipulating that there is a dispute, like the option of invoking the Public Speech and Participation Act is still available to respondents in this case.
Especially since the dispute could be resolved theoretically through discovery, right?
Theoretically, but it's
I mean, you will often take discovery in a case and then move for summary judgment. Couldn't that happen here?
It could, but plaintiffs have not requested discovery. So the case doesn't turn on that in this situation.
I'm saying if we think there's a disputed material fact that has to be resolved and we remand the case, you seem to be suggesting that in answer to Judge Henry's question, you seem to be suggesting that does not necessarily deprive you of the ability to nevertheless invoke the anti-SLAPP statute.
Correct.
Below, if we send it back. I mean, you might want to take discovery, right? You might want to put Mr. Bremerley under oath and take his deposition and get the information you need to demonstrate that this is protected speech. This is not defamatory.
Correct, but the state law provides extra protection to defendants such as Animal Action Now, where they wouldn't need to go through that extra process of discovering because the legislature recognized that these SLAPP suits are a recurring issue, and small nonprofits such as Animal Action Now don't necessarily have the resources to carry on these litigations that were brought by plaintiffs.
But if we decide that there is a dispute of facts and we remand so that can be resolved in one way or another, there's still extra protection available to you under the statute, isn't there? Because you still get attorney's fees.
Correct. Correct. That's one of the layers of protection, but the expedited discovery is just as important for reasons that I stated.
You mean stay discovery. You mean stay discovery, not expedited.
Yes, stay of discovery. I misspoke, sorry.
That's okay.
And so both of those provisions are just as important to.
Well, your colleague said that the right to attorney's fees was the most important part of the statute. Do you agree with that?
Yes, the right to the attorney's fees is what stands out the most. And your honors, may I turn to my second point?
Sure.
So under the plain language of the Free Speech and Participation Act, the speech that respondents engaged in, which included the uploads, the interviews, the video footage, all of that speech falls under the plain meaning of subsection C. And even if this court declines to equate those forms of speech to the ones listed, the catch-all phrase or other similar works leaves room for courts to include more speech, such as in this case, the social media posts that aren't explicitly named, but in light of the legislature's intent for the statute to be construed broadly and to prevent these meritless lawsuits, this court should find that all of the speech by Animal Action Now is covered. Thank you, Your Honor.
Thank you very much. All right, now we're going to get to the rebuttal by Mr. Stremkowski, I think.
Yes, Your Honor.
All right, you have 2 minutes.
Thank you, Chief Judge. Briefly on rebuttal, respondents seem to allege for the first time on appeal that Mr. Bremerly's affidavit is essentially a sham affidavit that is covered under Rule 56. In response to questioning from Judge Hotz and Judge Meyer, respondents couldn't point to a particular piece of authority that would suggest that we could throw out that affidavit to avoid a factual dispute. But Rule 56, subsection H covers this. If they wanted to challenge below that Mr. Bremerly's affidavit is essentially a frivolous affidavit, one filed without merit that has no factual support, they needed to challenge that by motion. They needed to provide notice that they were challenging it as a sham affidavit, and Mr. Bremerly needed a chance to respond to that sort of allegation. They didn't do that below. It's inappropriate for that to be alleged now for the first time on appeal. And that speaks to a more fundamental problem with respondents' position. Cherry picking one statement out of paragraph 12 of Mr. Bremerly's affidavit and calling it a conclusory statement overlooks the other 20 paragraphs of the affidavit, which are supported by factual allegations. They're supported by ratings by the American Humane Society, by the American Egg Institution. And those create a triable issue of fact. And not only that, respondent alleges that the Bremerlys did not properly allege a defamation claim in this case. That's entirely what the Bremerlys did in their complaint. And Mr. Bremerly is allowed to support that allegation, which is not being tried under a Rule 12 plausibility standard later, with the sworn affidavit that is providing factual matters that create a genuine dispute of material fact and trigger the Seventh Amendment.
Quickly, Mr. Stremkowski. So if these need to be tried out, these questions of fact, it's your position that we need to deny the defendants access to the Public Speech Act, the Anti-SLAPP Act, and we have to go through Rule 56 proceedings because of the jury right or whatever associated with their defamation claim? Or do you concede that we can remand this and instruct the district court to invoke paragraph 5 of the Public Speech Act and collect discovery relevant to the anti-SLAPP claim, and thus still consider this on an expedited basis?
Chief Judge Meyer, I see my time has expired. Can I briefly answer that question?
Please answer Judge Henry's question.
Judge Henry, I think either of those routes are appropriate. This court could decide that the supremacy clause is triggered by the federal rules and just say that the statute can't apply in a federal diversity action, and that can be the end of it. But if this court wants to remand, say that a proper summary judgment procedure needs to be carried out and that further discovery might be needed to resolve some factual issues, this court could certainly do that as well. Thank you.
Thank you very much.
Okay, thank you all. So we have some time now before the judges confer. If you would like to provide some feedback to the participants, then we'll clear the courtroom and allow the three of you to confer with each other about your ruling.